I'm hiding in a tiny phone booth in an office, and I'm here to give you my quickest reaction to the filed motion for summary judgment in the Lively versus Wayfair matter. I'm Little Girl Attorney. I'm a California employment lawyer, and I've been covering this case. And yesterday's filing, last night's late night motion for summary judgment filing, was a banger, was a game changer. Before I get into that, I first want to say that I am shocked that after all of the posturing, all of the extensions requested, all of the statements made by Lively's counsel that she was planning to file a motion for summary judgment, she didn't. She didn't file one. And frankly, I'm not sure what she would have filed it on. My best guess was that she would file it with respect to Wayfair's affirmative defenses, because Wayfair has to prove those affirmative defenses in the same way that Lively has to prove all of her claims against Wayfair. And that's really the only thing that I could think of that made sense for her to file a motion for summary judgment. But now it's clear that that was just blustering, and maybe, just maybe, her attorneys have gotten through to them that it would have been a really bad decision to file a competing motion for summary judgment, and they're saving all of their best opposition evidence for the opposition to this motion. This motion, as written, is also a very beautiful piece of advocacy. I am incredibly impressed with how they approached this particular motion. Motions for summary judgment are challenging because what you're doing is saying, court, there's no issue of fact. You don't need to allow this to go to trial because the evidence shows that there's really no genuine question of fact. And the law is on our side here, as well as the evidence. But what they did here, and I really encourage everyone to at least read the introduction and the statement of facts. So the two first parts of this motion. It's a very long document, and I think it's like 73 pages. But the introduction and the statement of facts lays out exactly how Wayfair views this case, and it cites to the evidence that they have to support how they view the case. And truthfully, I think they did a beautiful job depicting exactly what happened and allowing themselves to tell the story. The only other time that we've seen them do that is when they filed their counterclaim against Lively and Reynolds and all the parties, and that got dismissed. So this is the opportunity for them to set the record straight as to what happened, to tell their side of the story, which is what their counterclaims were meant to do. So this is the first time that we're hearing in their voice the full context of what they believed happened and placing all of the allegations into the context of what happened. Not only do they provide us the context, but they tell us that even if you were to take all of these things as factual, it doesn't arise to an actual claim. What I was most surprised about was that they went for the sexual harassment claim. So typically in employment cases, it's very, very difficult to win a sexual harassment claim defense at a motion for summary judgment, because ultimately it can come down to a he said this, she said this, meaning that she's going to say, and I don't mean Lively, but in a typical sexual harassment case, a plaintiff will say, he touched me, he looked at me funny, he groped me, whatever. And then the defense will say, no, he didn't. So therein lies the problem. There's always an issue of fact, because you don't typically have a defendant come out and say, yeah, I did touch her, or yeah, I did grope her, or yeah, I did wink at her or make her feel uncomfortable. So a lot of times defendants won't move for sexual harassment unless there's like a statute of limitations question or some other legal procedural thing. But usually on the facts of what happened, you don't have defendants moving for sexual harassment, meaning moving for summary judgment on sexual harassment. And here Wayfair did that, and they did it beautifully. And they did so by carefully illustrating that the evidence and allegations match, by saying that if you take these allegations and view them in context of what happened, there is no issue or question of fact. And so if you take all of that, It does not rise to a hostile work environment, to an actionable harassment claim. And this is the line that I think really sums up this defense and this particular claim. Lively knowingly took on a lead role in a provocative, sexually charged film based on a book famous for its intense, intimate scenes. When viewed in context, no reasonable juror could find that the handful of comments and miscommunications Lively has mustered amounts to sexual harassment. And what they do afterwards is illustrate all of those allegations within context, with other evidence to explain the allegation. So they're not actually challenging the allegation, they're challenging how it has been portrayed in the pleading and showing evidence around what that is, clarifying what the claim is, essentially, putting it into context and saying, if you take all of that and look at all of it, it does not amount to severe and pervasive harassment. It does not amount to actionable harassment. And I love that they were able to use the McSweeney case. The McSweeney case involved the Desperate Housewives. Is it Desperate Housewives? And it involved harassment or hostile work environment claims. And it was a Judge Lyman case in the Southern District of New York. And they were able to quote that context matters. So, for example, they introduce evidence of video footage around the claim that she says she was called sexy, and showing that it was in reference to her wardrobe, and it was entirely unremarkable. She was not scantily clad, she was not dressed provocatively, she was literally in a fleece onesie. They address how a sexual harassment claim could be on the basis of gender. So they go through and question whether the allegations were really turning on because of the fact that she was a woman. For example, they say that Baldoni spoke with Lively about topics like sexuality, consent, pornography, not motivated by her gender, but because she was a co-lead and collaborator in a film exploring adult themes. And they reference some redacted, looks like deposition testimony that I imagine says something about how these conversations were done in front of male and females. And then there's some reference to Lively's testimony that I imagine says something about how she participated in those conversations. Really need to see the unredacted copy. I cannot wait for it to be unsealed. So if there's testimony about her also saying things like, oh, we need this to be hotter or whatever, then she's also participated in the same thing that she's accusing him of, which proves that he's not doing it around her because she's a woman. Like, Heath didn't show the post-birth video of his child's birth to her because she's a woman. He showed it to her because they were filming a birthing scene. And there's just something about this one phrase or this quotation from a deposition that really just kind of gave me chills, where she says, they're talking about Lively asserted that Heath inappropriately glanced at her after being invited into her makeup trailer, and she was undressed. And it says Lively herself dismissed the idea that he did it for, he was trying to cop a look. And I don't know what it is, but something about that just makes my spine tingle. Obviously, she's admitting that he wasn't trying to cop a look, but now she's suing him for it. Anyway, this video is about how they put the sexual harassment allegations into context and beautifully avoided creating an issue or an issue of fact for the judge. Because how is Lively going to object when they were like, yeah, we did show this video, or yeah, this did happen, but here, you should also know about what happened around it. And what happened around it shows that this doesn't really arise to a true sexual harassment claim. And frankly, I agree. And I think it was good that they at least went for it. They may not win on this because it's risky, but what do they have to lose? Now they've given the judge the full context of what happened. And it's a preview of what a jury would see. I have more work to do, and I have a flight to catch tonight, but I promise you I will be back with more.